USCIS FE shock. Why your I-485 and I-140 forms are getting rejected. The rejection notice came back in a manila envelope. No phone call, no warning, no second chance. Just a form returned in the mail with a check still inside it, uncashed, and a single stamped notice explaining that the entire package had been rejected before a single officer ever looked at it. The family had spent 4 months preparing that application. They had gathered employment records, medical examination results, police clearances from 2 countries, affidavits of support, and photographs taken to exact USCIS specifications. Their attorney had reviewed the forms twice. The filing fee check was written for the amount listed on the USCIS website when they first began preparing the case. That was the problem. Not the forms, not the evidence, not the photographs, or the police clearances, or the affidavits. The check. By the time they mailed that package, USCIS had updated its fee schedule. The amount on that check was no longer the correct amount, and USCIS, operating under its published rejection policy for incorrect fees, returned the entire package without review. The clock had been running. Their priority date was current. The window to file was open. And now, because of a fee discrepancy that could have been caught with a single verification step, they were starting over. Most people assume that a rejected package just means a delay. Sometimes it does. Sometimes it means something much worse. Today, you are going to understand exactly why I-485 and I-140 packages are being rejected at elevated rates right now, and exactly what you need to check before you ever seal that envelope. For months now, there had been signals, not from formal USCIS press releases, not from the Federal Register, just signals that something about the fee collection system was creating unusual volume in the rejection pipeline. Immigration paralegals in busy practices were tracking patterns. Cases that should have moved forward were coming back. Packages that were prepared carefully, filed correctly in every substantive way, were being returned on procedural grounds that had nothing to do with eligibility. USCIS has always been strict about fees. That is not new. What is new is the combination of factors that has made fee errors more common, more consequential, and more difficult to recover from than at any point in recent memory. The agency underwent one of the largest fee schedule overhauls in its history. New fees took effect. Old fees became invalid overnight. And the transition created a window of vulnerability that caught thousands of petitioners and their representatives unprepared. Immigration attorneys who monitor USCIS rejection trends started recognizing the indicators early. The first indicator was the volume of returned mail reports appearing in practitioner forums. These are not public statistics. USCIS does not publish a monthly rejection count broken down by reason. What gets reported is what attorneys see in their own practices and share with each other through professional networks. The second indicator was the specific pattern of the rejections. They were not coming back because of missing documents. They were not coming back because of incomplete forms. They were coming back because the fee was wrong. Sometimes by a few dollars, sometimes by a few hundred. The third indicator was the speed. USCIS lockbox facilities, the processing centers that receive and sort incoming mail before any substantive review begins, were returning packages faster than normal. That speed meant the rejection decisions were being made at intake, not after review. Fee errors were being caught immediately. And when lockbox rejections move fast, the cases behind them fall further behind. Early in the post-fee schedule update period, immigration legal organizations detected what they described as a systemic fee confusion problem, including a type of filing error not commonly seen in experienced petitioners. Attorneys who had been filing I-485 and I-140 petitions for years were submitting packages with incorrect fees because they had relied on fee information that was accurate before the update and never refreshed their internal documentation. This is not an indictment of those attorneys. It is an illustration of how rapidly the fee environment changed and how much institutional inertia exists in any busy legal practice. The new USCIS fee schedule introduced separate fees for I-485 applicants based on age. It introduced new biometric service fee structures. It created fee exemptions for certain categories that had previously paid full amounts, and it eliminated exemptions for other categories that had previously not paid at all. The matrix became more complex than it had been in over a decade, and USCIS did not build in a grace period. There are really only 3 situations where a fee error might be forgiven without full package rejection. The first is when the error is in USCIS's favor, meaning the petitioner overpaid. USCIS policy on overpayments is more flexible than its policy on underpayments. Overpayments below a certain threshold are sometimes accepted without return, though this is not guaranteed. The second is when the petitioner files with a fee waiver request and the waiver request is properly documented. Fee waivers are available for I-485 applicants who can demonstrate inability to pay. They require Form I-912 and supporting financial documentation. If the waiver is approved, the fee issue is resolved. If it is denied, the case still faces rejection. The third is when the payment method itself fails and the petitioner has an opportunity to correct it before final intake processing. This window is extremely narrow and cannot be relied upon as a strategy. In every other situation, an incorrect fee results in rejection. No partial credit, no administrative correction, no phone call asking you to send the right amount. The rejection notice that went out in that period to thousands of households was not symbolic. It was not a warning shot. It was operational. And it caught people at some of the most vulnerable moments in their immigration journey. Moments when they were counting on a current priority date, a filing window, a transition from non-immigrant to immigrant status. Immigration attorneys who studied the rejection data described the pattern as systematic, in some ways preventable, and most importantly, still ongoing. The fee update did not eliminate future confusion. It created a new baseline that will remain unfamiliar to some portion of filers, particularly self-represented filers, for as long as the current fee schedule remains in effect. The response from the practitioner community was clear. The only defense is verification at the moment of filing, not at the moment of preparation. Their guidance became among the most consistently cited in immigration legal webinars seen in the past year. Verify the fee on the day you mail, not the day you prepare, not the week before, the day of mailing. Because USCIS has the authority to update fees with relatively short notice, and any package in transit when a fee update takes effect is subject to the new amounts upon arrival. Today, the data confirms that the most common source of I-485 rejection is not the wrong form version, though that also causes rejections. It is not missing initial evidence, though that causes rejections too. It is incorrect fee payment, including cases where the check amount was accurate when written, but became inaccurate before the package arrived. USCIS lockbox facilities process incoming mail by the date of receipt, not the date of mailing. If your package was mailed on a Tuesday and a new fee took effect on Wednesday, and your package arrived on Thursday, USCIS will apply the Thursday fee to your filing. Your Tuesday fee amount will not be accepted. This is not theoretical. This is documented in the USCIS policy manual. They rejected packages targeting applicants across all major I-485 categories, including applicants with approved I-140 petitions who had been waiting years for their priority date to become current, applicants who had valid employment-based petitions, and immediate relatives of U.S. citizens whose cases are not subject to numerical limits. None of that history protects you from a lockbox rejection for incorrect fee. They acted before the petitioner could respond. The package was returned. The priority date remained current, for now. But the refiling required new photographs, In some cases, a new medical examination, if the original had expired, and a new check in the correct amount. This wasn't symbolic, it was mechanical, and that is what made it so difficult to accept. There was no officer making a judgment call. There was no discretion being exercised. The system applied its rule and returned the package. The I-140 side of this equation carries its own set of complications worth understanding separately. For employer-sponsored immigrant petitions, the I-140 filing fee, as of the most recent USCIS fee schedule, is $715. That number changed from a previous amount, and some employers, particularly those who prepare their own petitions without ongoing legal counsel, filed with the old amount after the new schedule took effect. The rejection consequences for I-140 are different in one important dimension. An I-140 petition that is rejected before acceptance does not establish a priority date. The priority date is only established when USCIS accepts the petition, meaning it is received, the fee is confirmed as correct, and the case is entered into the system. A rejected I-140 sets no priority date. If the priority date cutoff in the relevant category moves forward after your I-140 is rejected, and before you can refile, you may return to a longer wait. If the cutoff moves backward, which happens in oversubscribed categories, you may be looking at a significant additional delay. This is not a recoverable situation in all cases. Some petitioners who lost their filing window because of fee errors were not able to refile in time to preserve the advantage they had worked years to reach. There is a specific population that faces elevated risk from fee rejection that is rarely discussed in general immigration content. That population is self-represented filers, individuals who prepare and submit their own I-485 or I-140 petitions without an attorney. Self-represented filing is legal. It is permitted by USCIS. For straightforward cases, it can be done successfully. But self-represented filers do not have access to the internal alert systems that law firms maintain. They do not receive emails from professional associations when fee schedules change. They rely on the USCIS website. The USCIS website does update when fees change, but it does not send notifications to people who visited the fee page 6 months ago and saved the information. It does not call you. It does not email you. It posts, and it expects you to re-verify. Self-represented filers who prepared their packages weeks or months in advance and then mailed them without checking the current fee schedule on the day of mailing are among the most common sources of lockbox rejections. This is not a failure of intelligence. It is a failure of the notification system. And until USCIS builds a meaningful alert infrastructure for fee changes, which it has not done, the burden of verification sits entirely on the filer. There is also a payment method dimension to this issue that catches people by surprise. USCIS accepts personal checks, cashier's checks, money orders, and attorney trust account checks for most filings. It does not accept cash. For some filings, it accepts credit card payments using Form G-1450. A payment that bounces, a personal check returned for insufficient funds, triggers a rejection that is even more difficult to recover from than an incorrect fee. USCIS imposes a returned check fee of $30, and depending on the category and the circumstances, may impose additional processing consequences. If you are filing I-485 for a large family, a principal applicant with a spouse and multiple children, the total filing fees can easily reach $5,000 to $7,000 or more, depending on the ages of the applicants and the biometric requirements. A personal check for that amount, if it bounces, creates a situation that compounds quickly. Attorneys consistently recommend cashier's checks or money orders for large filings. The slightly higher cost of a cashier's check is negligible compared to the cost of a rejection and the timeline consequences that follow. The most current I-485 fee structure requires careful attention to the applicant's age. Applicants who are 14 years of age or older pay a different amount than applicants who are under 14. The biometric services fee applies differently depending on the applicant's age and category. Applicants over 79 are exempt from the biometric services fee under current policy. If you are filing for a family with children and you apply the same fee to every family member regardless of age, you will underpay for some applicants and may overpay for others. The underpayment will trigger rejection for those applicants. The overpayment may or may not be processed without issue. This is not a minor administrative detail. It is the single most common fee error in family-based I-485 filings. The practitioner guidance on this point is consistent. Build your fee calculation from the USCIS fee schedule table individually for each applicant. Do not apply a single amount to the entire family. Verify the age-based exemptions. Confirm the biometric requirements for each individual. Then write a separate check or money order for each applicant if the fees are different, or combine only when the amounts have been individually verified. The verification process takes 20 minutes. The rejection and refiling process takes months. As this wave of fee-related rejections continues to move through the immigration system, more families will learn this lesson the hard way unless someone explains it clearly before it happens to them. The USCIS fee schedule is public. It is updated on the USCIS website. It is your responsibility to verify it on the day you file, not the day you decide to file, not the day you prepare your package, but the day the package leaves your hands. That one step, verification at the moment of mailing, is the difference between a case that moves forward and a case that comes back in a manila envelope with your check still inside it. Knowing this right does not make you a criminal. It makes you smart. It means you are prepared. It means you are protecting your family from a rejection that costs months, money, and in some cases, a priority date you spent years waiting to reach. Share this video with anyone you know who is preparing an immigration filing. It might save their case. Subscribe to Visa Status Radar for more protection. We protect you with real information as the next phase of immigration policy unfolds.